In today's Spring GX multidisciplinary lecture, I'm going to discuss some of the basic concepts and fundamental issues of jurisprudence, focusing on students who do not specialize in law. As a legal scholar, I am tempted to talk meticulously and precisely, raising exemptions and reservations. Given the time constraints, however, I will restrict myself to the basics. You may assume that legal scholars know everything about laws. However, jurisprudence covers a wide range of specialties. My expertise is Japanese administrative law, a branch of law governing the organization and operation of regulatory agencies in Japan. Therefore, today's lecture will primarily relate to administrative law. The major topics of today's lecture are 1. The process by which laws are formed on the basis of the will of each person, and 2. Contemporary issues with the lawmaking process. A right is a power or capacity that a person has under the law, and the law is formed on the basis of the will of each person. In other words, today's lecture will revolve around the interplay between the lawmaking process and the rights of persons. What does the term law bring to your mind? Laws may originate from social norms and practices. In particular, commercial law and international law strongly reflect common practices. But from the standpoint of my expertise mentioned earlier, I will specifically talk today about the roles of the legislature and the judiciary in national lawmaking. In other words, the legislative activity of the National Diet and the court rulings will be the focus of our discussion. The table shown in the slide compares the characteristics of the national legislature and the judiciary in lawmaking and human rights protections. The Diet makes laws. Its members represent the nation. They're selected by the adult citizens of the country who have equal voting rights. The Diet can discuss any topics it deems appropriate. Its discussions are not restricted by the application of existing legal norms. Ultimately, bills are enacted by majority vote. In a nutshell, laws are formulated through the democratic process. By contrast, courts and judges are granted independence from other actors in the government and the society. Judges are not allowed to initiate court hearings on the topics of their preferences. Civil and administrative litigations starts when a person or persons files a complaint to defend their rights. In a criminal trial, the prosecutor litigates criminal charges, and due process is taken to protect the defendant's rights. Alleged breaches of personal rights start court procedures. When a lawsuit is legitimately filed, the court must make its decisions. Trials are typically based on the two-party adversarial system, whereby the claimant and the defendant present their arguments and supporting evidence. The judges hear the cases, apply legal norms, and make judgments based on their consciences. You may consider that the court's role is merely to implement or apply Diet-approved laws to individual lawsuit cases, and that the Diet is solely responsible for legal development. To the contrary, courts play a major role in lawmaking because Diet-approved laws typically leave room for interpretation, and courts shape the legal framework by presenting judicial interpretations. Since laws are written in human language, they are inevitably subject to interpretation. From a more positive perspective, subjectivity to interpretation enables laws to be applicable to a wide range of social events, including new, emergent situations. Some legal provisions, such as the rule that vehicles must drive on the left-hand side of the road, leave little room for interpretation, but such provisions are the exception. For example, let us turn our attention to Article 2, Paragraph 1 of the State Redress Act. This provision stipulates that national or local authorities must compensate for the damage attributable to a defect with the facilities or installations under their management. This provision simply reads as follows. When loss or damage to another person is caused because of a defect in the placement or administration of a road, river, or other public structure, the state or public entity assumes the responsibility to compensate therefor. According to this provision, the responsibility for compensation hinges on the presence or absence of a defect. However, the decision on the relevance of this provision to a given case is not simple and straightforward. The court will interpret the term defect to determine its scope of application. For example, there was a road accident where a person driving a car was killed by rocks that fell on him, and his bereaved family filed a claim for compensation. In the ruling of this case, the Supreme Court found a defect, stating as follows. The liability for compensation by the state or public entity does not require the proof of negligence. It can be inferred that the costs involved are considerably high, and the prefecture responsible for managing road expenses would struggle with budget measures. However, it cannot be assumed that this would immediately exempt the prefecture from liability for damages caused by defects in road administration. The court denied the local government's plea of budgetary constraints, in which they defended their shortcomings on the basis of insufficient budget. The State Redress Act does not mention whether or not the plaintiff must prove negligence on the part of national or local authorities. In addition, the Act does not specifically mention whether or not the defendant's claim of budgetary constraints is admissible. The court's interpretation of the legal provisions shape the legal framework. There are several methods of statutory interpretation. Literal interpretation is a relatively straightforward approach whereby the terms are read and understood in their true literal sense. Legislative intent interpretation is a practice to determine the scope of the law on the basis of the legislator's discussions at the time of the passage of the bill. Legal interpretation becomes a highly creative work when systematic interpretation or teleological interpretation is pursued. The former attempts to achieve legal consistency between a particular provision and other parts of a given law, or between the law under consideration and other ones. The latter aims to interpret a law based on its objectives, underlying legal principles, and basic concepts. Let us consider the State Redress Act Article 2, for example. Article 717 of the Civil Code, which came into existence long before the State Redress Act, defines private parties' duty of reparation. This article decrees that if damage is incurred by a defect in the structure on a piece of land, the possessor or owner of the land must compensate for the damage. In relation to the term defect as used in this Civil Code article, it is commonly understood that proof of negligence or misconduct contributing to the defect is not necessary. The systematic interpretation aims to interpret Article 2 of the State Redress Act in line with this interpretation of the Civil Code. In the case where the activities that the national or local governments conduct for the public benefit cause damage to a private party, the reparation may be paid from tax money, thereby distributing the burden equally among taxpayers. This is termed the principle of equality before public burdens. This principle was developed primarily in the French system. Based on this principle, the teleological interpretation of the State Redress Act suggests that a defect can be approved in the absence of a proof of negligence or misconduct.
不注意の証明は必要ないといったような解釈をするというのが、目的論的解釈ということになります。
Thus, court's interpretation shapes the legal framework. This process may give rise to several questions. As I mentioned earlier, the court starts a hearing when a private party files a lawsuit for restoration of their rights. One may ask how the judicial interpretation that a court makes in a given lawsuit can influence the rulings on other cases. In other words, one may consider that the interpretation made in a given case should be effective only for said case. In several countries, Supreme Court verdicts, specifically the reasons section that describes the grounds and reasoning underlying the decisions, bind lower courts. There are two major legal systems in the world. Generally, legal systems markedly differ between the UK and US on the one hand, and France and Germany on the other. These are called Anglo-American, common law, and continental law systems, respectively. In the Anglo-American law system, the doctrine of precedent, or stare decisis, is applied, under which the court must follow earlier judicial decisions on the cases similar to the one under consideration. In the continental law system, by contrast, the stare decisis principle is not legally, de jure, binding. In practical terms, however, the judgments of the Supreme Court have a de facto binding force on lower court rulings, because the Supreme Court will probably overturn the lower court decisions that contradict their previous judgments. Regarding the stare decisis principle, the Japanese system adopts a stance similar to that of the continental system. Regardless of whether precedents are legally or practically binding, they do not have a perpetual effect. When deciding on a case, the court may declare that it will depart from the precedents. One very recent example of the Japanese Supreme Court departing from precedents relates to a case where the local diet decided to ban the attendance of one of its members, and this person filed a claim with the court complaining that the ban was illegal. Previously, the Supreme Court held that such a matter should be settled within and by the local diet, and refrained from making a judgment on whether the ban was legal or illegal. Recently, in 2020, the Supreme Court declared that it would overturn its previous case decisions, stating that courts will judge the legal dispute concerning the local diet's ban on the attendance of its members. Another point to note here is that preceding decisions, whether they may be binding de jure or de facto, have less force than the law because these decisions will remain linked to their specific cases. This allows the court to interpret and restrict the scope of applicability of the preceding judgments. By emphasizing the differences between the current and previous cases, the court may decide not to be bound by the precedents. Let me give you an example. Earlier I presented the Supreme Court decision referencing Article 2, Paragraph 1 of the State Redress Act. This case related to a rockfall traffic accident. After this ruling, a lawsuit was filed to ask for national reparation for the damages caused by a river flood, claiming that the national government failed to take sufficient flood prevention measures. The lower courts applied the Supreme Court's criteria for remedy made in relation to the rockfall accident, and overruled the government's defense argument of budgetary constraints. However, the Supreme Court accepted the argument of budgetary constraints, and declined the plaintiff's claim on the government's defect and responsibility for compensation. The Supreme Court argued that the framework of its judgment on the rockfall accident should not be deemed applicable to the defects in river management, The court pointed out that the risks of traffic roads and those of rivers should be addressed from different legal perspectives. Because traffic roads are installed and opened for public use from the outset with safety measures to handle normally predictable disasters, whereas rivers inherently carry the risk of disaster occurrence.
で逆にもちろんですね、後の裁判所が先例を類推できる事案であると言って、先例を適用するということ。
Alternatively, the Supreme Court may apply the preceding case judgments to the case under consideration on the basis of their similarities. What complicates this issue is that there are several cases where the Supreme Court made tacit corrections to and restricted the scope of the preceding interpretation, presumably because the precedent involved certain legal problems. Thus, interpretation of a precedent is a multifaceted process involving the assessment of a variety of conditions and interests. As explained here, the Diet's legislative efforts and court ruling activities play an interconnected role in lawmaking. The diagram summarizes what I have discussed so far. Particular attention needs to be paid to the interconnected roles the Diet and courts have in public legal matters. As I mentioned earlier, the court initiates its judicial proceedings only when a lawsuit is filed. This marks a striking difference between the court and the Diet. Suppose that anyone, under any circumstances, can bring a litigation on public administrative or legislative issues. In other words, let us assume that any registered citizen has the right to file a lawsuit concerning public matters. Such action is often referred to as an actio popularis. An actio popularis would abolish the requirement on the court to initiate its judicial activities only when it receives a complaint. Thus, the actio popularis principle would end up allowing the court to replace the legislative and administrative bodies and usurp the Diet's responsibility to decide on the issues of public interest through the democratic process. Unlike the legislative and administrative bodies of the government, the court is not at liberty to decide the extent of their investigation and rulings. The court must make definite judgments on legitimate complaints. Thus, the actio popularis principle, which would allow any person under any circumstance to bring a lawsuit, would overload the courts, incurring enormous budgetary, labor, time, and social costs. For these reasons, the actio popularis principle has not typically been accepted in most systems, where restrictions have been imposed on the standing to sue or plaintiff qualification. As far as the latter half of today's lecture is concerned, the standing to sue or plaintiff qualification refers to the right to file a lawsuit. If a party without standing to sue files a lawsuit, the court will simply dismiss it as inadmissible on the basis of the absence of cause of action. The court will not judge whether the accused public action of the legislative or administrative body is legal or not. The court has a gatekeeping function and shuts its doors to applicants without legal standing. Standing to sue is primarily granted to those parties whose rights or legally protected interests are infringed by misconduct. As a result of international comparisons of the scope of standing between Japan and other countries, scholars have published critiques arguing that Japanese courts set very narrow standing requirements out of fear of rise in vexatious litigations and judicial overload. In the countries that admit broader standing qualifications than Japan, new issues are emerging with respect to standing qualifications. This is particularly the case with climate change litigations, which I'm going to discuss now. In the latter half of my talk, I will mention three basic contemporary issues that relate to the law-making process. The first relates to whether litigation asking for the protection of the human environment or ecosystems can be admissible. As I mentioned just now, the right to bring a suit is limited to parties who claim to have suffered rights infringement or damages. Japanese courts have granted legal standing for individuals who claim violation of their rights and interests relating to sunlight access or urban landscape. However, environmental deterioration and adverse ecological impact are not likely to constitute infringement of people's rights or legally protected interests, because access to natural environment or ecosystems is hardly likely to be individually justifiable rights or interests. Put differently, if rights or interests pertaining to enjoyment of the natural environment and ecosystems should be granted to individuals, it would open the door to actio popularis because every citizen would be entitled to sue. Japanese courts generally admit neither such rights and interests nor litigation claims based on them. In several lawsuits, wildlife and natural species appeared as named plaintiffs. In the past, a caveat was filed against the National Isahaya Bay Reclamation Project in Nagasaki, in which mud skippers and several other wild animals were named as co-plaintiffs. The court shut its doors to this appeal, refusing to initiate its hearing procedure. Given that courtroom communication is made in human language, it is unlikely that such a case would proceed to trial. However, shutting courtroom doors to complaints about environmental and ecosystem issues raises other issues with the legal system. It suggests possible inconsistency and disparities in the protection of rights and interests between economic and environmental disputes. Plaintiffs who appeal concerning the breach of their economic interests can have a great opportunity of protection through court orders because they can prove their own rights with relative ease. On the other hand, environmental rights and interests are less likely to be reducible to individual community members, and hence they may have less chance of legal protection. Regarding this challenge relating to the protection of interests that are not reducible to individuals or the interests that individuals are not deemed appropriate to claim, often referred to as collective interests, one possible solution is to define a legal procedure whereby the relevant administrative agency approves and grants legal standing to certain organizations that have the capacity to articulate collective interests. This procedure is termed a class action suit, and several examples of class action cases can be found in the area of consumer protection. However, no environmental laws in Japan have provided for class action suits. The Aarhus Convention, which many European countries have ratified, obligates contracting countries to grant legal standing to qualified, non-governmental environmental organizations. Apart from the Aarhus Convention, the European Court of Human Rights recently released a landmark decision regarding the European Convention on Human Rights. In its verdict, the court acknowledged Switzerland's inadequate measures against climate change, particularly insufficiency in setting greenhouse gas reduction targets and absence of timely and appropriate action to implement relevant legislation and measures. The court confirmed a violation of Article 8 of the European Convention on Human Rights. This article stipulates the right to respect for private and family life, encompassing lives, health, well-being, and quality of life. This case was brought by several individuals and their association. The individual applicants were seniors who complained of health exacerbation during heat waves. The association applicant was a non-profit organization established in Switzerland to promote and implement effective climate protection, whose members were mostly elderly people. In its ruling, the European Court of Human Rights addressed the legal standing of the applicants. Climate change is an urgent concern of humankind. Human activities can inflict irreversible damage on the entire human population. At the same time, it's unknown who causes what harm and who are harmed to what extent. These unknown elements complicate the determination on standing qualifications. The European Court of Human Rights reiterated that the actio popularis is not permitted, since the Court of Justice should not get involved in political issues that ought to be settled in a democratic manner. The court declared the complaints of the individual applicants inadmissible because it was uncertain whether they currently had or would in the future have serious health damage. By contrast, the court affirmed that the association applicant had the right to file a complaint of violation of Article 8 of the European Convention on Human Rights, taking note that the members of the association were mostly elderly people who were vulnerable to the adverse effects of climate change. Whereas I understand the court's judgment on Switzerland's failure to take adequate measures to protect individuals against the adverse effects of climate change, I believe that further consideration is needed regarding the court's decision that the individual applicants were inadmissible, whereas the association applicant was admissible. The court's ruling opened its doors to class action suits over climate change while avoiding actio popularis applications. A second issue relates to the interest that future generations will have. This issue poses a fundamental challenge to lawmaking, and its impact should be greater on the Diet than on the court. Citizens may have a wide range of opinions on future generations' interests. By exercising equal voting rights, they contribute to the process of lawmaking. However, this process is carried out only by those who are currently adults, excluding minors and future generations to come. In an aged society, younger adults participate in the process in smaller numbers than older adults. If the current generations continue to usurp available resources and leave fewer resources for the next ones, it'll give rise to intergenerational conflicts of interest. In the climate change verdict mentioned just now, the European Court of Human Rights pointed out that such intergenerational issues are involved in the challenges of climate change. Moreover, intergenerational issues relate to accumulated national deficits. As a possible solution to overcome such problems, one may propose to increase, say, double the weight of the vote for underrepresented younger age groups. However, this approach to modifying the electoral voting system would contradict one of the fundamental principles of democracy: voting equality. Practically, the Diet must also address issues that involve no intergenerational conflicts. Differentially weighted votes will cause disadvantage to the legislative decision-making mechanism when it addresses such non-intergenerational issues. Moreover, this approach could end up maintaining rather than resolving intergenerational conflicts of interest. These considerations suggest that intergenerational issues should be settled by introducing new procedural mechanisms. One option is to establish a new national referendum system that will allow the public to vote on a very limited and specific proposal. A second is to create a new agency that has the power to call on the Diet to reconsider its decisions on the basis that they may disfavor future generations. A third is to oblige the Diet to assess and predict the effects that the bills under consideration will exert on future generations. Still another option is to encourage the court to take note of the interests of future generations in its judgment.
でこういった手続きによる解決の一つとして裁判所が将来世代の利益を考慮して判断を示すということが考えられます。
In this regard, the groundbreaking climate change order that the German Federal Constitutional Court made during the COVID-19 pandemic deserves attention. The court ruled that Germany's Climate Change Act was partly unconstitutional, i.e., against the German Basic Law, on the basis of the government's failure to sufficiently reduce national greenhouse gas emissions by 2030, and the absence of provisions for emission reduction from 2031 and onward. The claimants of this litigation included environmental associations. However, the court denied the standing of the associations to lodge a constitutional complaint on the basis that such right was not stipulated in the Constitution or other laws. This ruling was opposite to that of the European Court of Human Rights explained earlier. By contrast, German individual claimants were granted legal standing. The court admitted possible violation of the claimant's right to life and health based on the first sentence of Article 2 of the Basic Law. While admitting that the federal government has a constitutional obligation to safeguard the health of citizens, the court found that the adopted provisions of the Climate Change Act do not violate this obligation. Nevertheless, the court concluded that the federal government violated constitutional law on the grounds that climate change provisions place major emission reduction burdens onto future generations after 2030 and thereby impair their fundamental rights of freedom in general, which are protected by constitutional law. According to the verdict, the legislator has an obligation to safeguard fundamental freedom over time and to spread the opportunities associated with freedom proportionately across generations. The court's recognition that such obligation is constitutional has attracted legal attention. Now let's turn to the third and last point. Legal communities have started to question the very basic tenet that law should be created by human beings. Currently, online communication tools and computational algorithms are used to assist in legislation, court proceedings, and judicial decision-making. At present, online diet discussions has not occurred because of conflicting opinions. Here, I'm going to discuss a very complex, or rather, extremely challenging topic. Regarding the diet's legislation mechanism, debates are ongoing whether laws can be replaced by deterministic algorithms, if not by artificial intelligence, AI. The major field of discussion is tax law. Since tax laws are very complex and difficult to understand, even for lawyers including me, it's understandably argued that they should be written in a much simpler style so that they can be readily transformed into an algorithmic format. However, the mainstream opinion is that laws cannot be replaced by algorithms. One of the arguments against replacing laws with algorithms is that it may interfere with the process of case-dependent interpretation of the legal text, whereby the differences between individual cases and changes in circumstances are appropriately taken into consideration. However, this counterargument is not generally relevant because the need to handle individual situations on a case-by-case basis depends on the nature of the law under consideration and does not apply strongly to tax law. A more fundamental issue relates to the current system where laws are enacted as a result of discussions by the nationally elected members of the Diet, and enacted laws must be disclosed to the public in an understandable format. Therefore, enabling algorithms developed by engineering experts or business suppliers to replace laws would interfere with this legislative system. In addition, if the content of the algorithms developed as a substitute to laws is disclosed to the public in a manner similar to bills and enacted laws, it may possibly give rise to willful and wrongful acts. Comparatively, the judicial process of the court, which involves interpretation and application of laws, may seem more receptive to replacement by algorithms. At last year's May Festival of the University of Tokyo, a group of law department students conducted a very exciting project, an AI moot court trial. In this demonstration, the AI judge delivered the verdict. However, the legal interpretation required for judicial decision-making is too complex for deterministic algorithms to replace. It is not a matter that can be solved by simply increasing the volume of data and arguments to train AI with. As I mentioned in the earlier part of this lecture, the legal interpretation involved in the judicial decision-making process requires judgment on the similarities and differences between the past, present, and possible future cases. As the state redress cases involving a rockfall accident and river flood indicated, a court's understanding of similarities and dissimilarities between related cases plays an important part of the judicial judgment. If the court deciding on a case leaves the litigation parties uninformed of its line of reasoning, hiding it in a black box, so to speak, this will constitute a major flaw in judicial accountability. In some instances, a court may judge a case in line with similar precedents. Other times, it may deviate from earlier rulings, taking into consideration changes in social situation and other elements. I explained earlier how a change from precedent is made. Even though a case may leave room for discussion about interpretation of legal provisions, relevance of the precedent, or validity of factual claims, a court's judgments have the power to bind the parties thereto. The court has this power as long as 1. Judges who meet particular conditions are appointed through prescribed procedures, 2. Judgments are made through prescribed hearing procedures under prescribed organizational conditions, i.e. judiciary system, and 3. The legal reasoning underlying judgments are adequately explained. This could sound like a professor's self-excuse for legal education. However, elucidating the mechanism of legal reasoning and judicial decision-making processes with the help of experts in information technology, neuroscience, and other disciplines will help review, improve, and validate these processes. Last September, the Department of Law hosted a symposium in collaboration with neuroscientists. This meeting discussed the similarities and differences in neural functioning between legal experts and non-experts engaged in sentencing exercises. I will close today's lecture by mentioning that jurisprudence studies are thus open to interdisciplinary research efforts. Thank you for your attention. ご清聴ありがとうございました。